Moment is here.
Thank you, Commissioner.
Judge, this is Roger. I've neglected to get the testimony of Lisa Starkeybaum in the record yesterday. I guess I'll wait till we get on the record, but just want to alert you to that.
Okay. I had a question about that. And
this is Mr. I'm sorry, go ahead.
No, go ahead, Mr. Keevil.
I was just going to ask, as to all of these items that official notice has been taken, are you going to have the parties who ask them to be have notice taken to submit actual paper copies of them? Or is there going to be a list? Or I mean, there needs to be some kind of documentation, I would think.
Yes, I will. I will ask the parties to submit or electronic copies, if not paper copies, of those.
Judge, Commissioner Holzman's here.
Oh, thank you, Commissioner. And I think I was going to ask, I thought maybe Mr. Keevil was getting to that. So staff had originally submitted rebuttal testimony of Hull, but then said yesterday, since the issues were settled, they didn't need to submit that. Is that still accurate?
Oh, sorry, what was that, Judge? I didn't hear it.
Staff had originally said that they had rebuttal testimony of Hull as an exhibit, but then you withdrew that yesterday because of the issue settling. Is that still accurate? That doesn't need to be admitted on the record. Okay.
That's correct. Mr. Hall's testimony only had to do with the Sierra Club issues.
Okay, great. All right. Looks like our court reporter, okay, she says she's good to go. I thought she was having an issue there. If everyone then is good to go, it looks like we can go ahead and go on the record. Good morning. This is January 28th, 2021, and we will be beginning again with Evergy's FAC Prudence Review hearing in file number EO-2020-0262. My name's Nancy DePel, and I'm the regulatory law judge assigned to this case. This is continuation day 2, and we had some initial housekeeping matters that we wanted to take care of, take official notice of some tariffs and so forth. I'm going to begin with the company. We had a discussion off the record about various tariffs that were discussed yesterday during the testimony, and the commission would like to make sure that we have all of the relevant tariffs in the record. So I'm going to ask that the parties each submit electronically copies of these relevant tariffs that you all discussed, and then the commission will take official notice of those. And I'm going to give everyone a week from today to file any objections or corrections that they think are needed to that list of tariffs. So I'm going to begin with the company, and Mr. Fisher, you had several tariffs that you thought were relevant. So
yes, Judge. The first tariff is a Kansas City Power and Light tariff, a PFC Mo number 2. It's original sheet 2.32 and 2.33. It's the residential programmable thermostat tariff, and The issue date is March 16, 2016, effective April 15, 2016. And then the accompanying tariff or the similar tariff for the Kansas City KCPL Greater Missouri Operations Company is PSC Mo number 1, original sheet number R-107 and R-108. And again, that's entitled the Residential Programmable Thermostat Tariff. They have effective or issue dates of August 28, 2015, effective January 1, 2016. And we can also add to our list the similar tariffs that are for the commercial and industrial program, the DRI program.
Okay, and you don't have those numbers right at this minute, correct?
I don't, unfortunately. Maybe we can get those before the end of the hearing.
Okay, but you will submit those. Will you submit those, say, in the next day, those numbers? And then if there's corrections or objections to those industrial numbers, people can make them within a week from today.
Yeah, I think if we take a break, we'll probably be able to get those to you.
Okay, great. And then also, I was interested in having the commission take notice of the Schedule 11 tariffs for SPP, the on their open access tariff. And the company was going to try to get me a good citation for that. Is that correct?
Yes, we can also include in the filing a copy of those tariffs from the SPP.
Okay, would there be any objection from any of the other parties to the commission taking notice of that Schedule 11 tariff? Assuming that
You're mute.
Mr. Kleiser, were you?
There's
Are
no
you
objection.
talking about the tariff that was in effect during the period, or I don't know if it's the same one that's currently or not.
Oh, that's a good point, Mr. Keevil. Yes, we would want the tariff that was effective at the time during the period. So if you would get us a citation for that, then Mr. Fisher, within
So
a day,
I guess
and then the parties can object to it if they think that's the wrong citation.
we
So-
have the tariff, Judge, and we can submit that in I'm talking about the Schedule 11 tariff.
Yes, the one that was in effect at the time.
That's my understanding. Yeah, I don't know. We'll just file the whole thing. It's like 11 pages long.
Oh, okay. Okay. I was afraid it was longer than that. So.
I was too.
Okay, well,
Just to correct, the Schedule 11 tariff is only 11. The SPP tariff is very voluminous.
correct. Okay. Okay, well, can you go ahead then and email that to me and the other parties, and then we can get that taken care of.
So yeah, we could, when we file our, well, did you want us to file these KCPL and GMO tariffs and this Section 11 tariff, or email it?
Well, I was gonna include it with the exhibits, but if you want to just go ahead and file it, that'll work too.
It's up. I just wanted to get clarification. I just didn't know if you wanted to file official filing in the docket or emailed. So just tell me your preference.
Go ahead and file it.
Okay.
That'll be clear. Okay, and then Public Counsel also had different tariffs that they thought were the relevant ones. Mr. Kleiser, did you want to go ahead and list those for us?
If the commission would prefer for me to list them now, I can do so. Alternatively, I can file a notice to take administrative notice either today or tomorrow that would just list them all out, include the electronic copies of all the tariffs that I wish to cite to.
Well,
It's up
can
to
you
the
go,
commission.
it's not an extensive list, correct?
Well, I wouldn't say, I don't think it's too extensive.
Well, go ahead and give me the list, and then I'll have you file them as a follow-up.
Absolutely. So for Evergy Metro, currently or previously K2PL, canceled tariff sheets 1.93, 1.94, 2.07, and 2.08, and then 2.09 through 2.14.
And do you have an effective date or a cancel date on those, just for reference?
I believe that they are different for different ones. Give me 1 second. The 1.93 that I'm referencing, according to the EFIS website that I have pulled up, says that they were game effective January 1st, 2016, canceled November 8th, 2019. For 1.93 and 1.94. For 2.07, became effective June 3rd, 2018, canceled November 8th, 2019. For 2.09, again, became effective June 3rd, 2018, canceled November 8th, 2019. You get all that?
Oh, yes.
All right. And then for Evergy Missouri West, formerly K2PL GMO, canceled tariff sheets R63.24 through R63.25, R84 through R85, and R86 through R90.
Okay.
You want me to go through the dates on those as well?
Yes, please.
All right, give me 1 second.
And a quick note, Judge, I've just been informed that people who are trying to listen to the stream through the website, there's no audio right now.
Okay, thank you. Okay, did you have additional dates, Mr. Kleiser? Are you still looking?
I am still looking. I apologize, Your Honor.
Okay, no problem.
Actually, Your Honor, honestly, I would prefer to simply get the sheets to you after the fact, if that is okay with you.
Okay. Okay, and my IT tells me that, and others tell me that the audio seems to be streaming just fine. So whoever is having issues, it's on their end. All right, so let me let me summarize so we have this all down correctly and you guys know what to do. So by tomorrow, I would like everyone who has one of those tariffs to go ahead and file that go ahead and file that in EFS. And then I will put out a little notice that the commission is going to take official notice of those and give you all until a week from today to object to any of those or offer any corrections. Does that sound, does everyone understand that?
Yes, Judge.
Okay, so we'll basically be leaving the record open to receive those at the end of the hearing. And Mr. Kleiser, are you talking to us?
No, Your Honor, I apologize.
Okay, I just wanted to make sure. All right.
Judge,
What
we
is-
also
Yes, go ahead.
we also discussed off the record the request of the company to take official notice of a stipulation in EO-2019-0132 and 0133. And
Yes.
order approving stipulation agreement. Would you like to take care of that at this time or later?
Yes, so let's go ahead and take care of that now.
Okay, the company would like for you to take official notice of a stipulation and agreement regarding extension of MIA 2 programs during pendency of MIA 3 case. And those files are file number EO-2019-0132 and -0133, dated February 15, 2019. And then in the same case, there is an order approving stipulation and agreement, which approves that stipulation dated issue date February 27, 2019. We'd request you take official notice of those.
And would there be any objection from any of the parties? Mr. Fisher had emailed, well, someone from KCPL had emailed those documents, but prior to the hearing. Would there be any objection?
Your Honor,
Yes. Go ahead, Mr. Kleiser.
sorry, this is slightly difficult. I'm not sure that I would object necessarily to the commission taking official notice. I'm more objecting, I guess I really had more of an objection towards the line of questioning that I believe Mr. Fisher intends to go down. Although this could be phrased an objection to the taking of commission official notice for this case due to relevancy. You know, I'm just going to lay out exactly what my issue is right now. And then again, the stipulation that you're asking to be taking official notice of contains provisions that explicitly prohibit its application in cases outside of that which it's meant to be settling. And I believe that the company is going to be attempting to argue that it's applicable to this case in contravention to those terms. So while I don't necessarily think the commission would be wrong to take judicial notice simply by virtue of the fact that it is within the commission's record, I do object to its use in this case, if that makes sense. And I am happy to read out the terms in particular that I'm referring to.
Okay. I understand that. And Mr. Fisher, this was the report and order that you are going to use in questioning Ms. Mantle, correct?
Yeah, I plan to do that. It's the same report and order that I discussed in the opening statement.
Okay. And I apologize. I was thinking that we were talking about the one that was used in questioning yesterday. And that was a report and order in EO-2015-0240 and 0241. And the attachment, which was a non-unanimous stipulation and agreement resolving MIA filings. So I was thinking that that was the order. So I won't take official notice of your other order at this moment.
Okay, we can do that in the cross. Is that when you'd like to do that?
Yeah, let's wait and hear Mr. Kleiser's objections during the testimony.
Okay, sounds good.
Okay.
Your Honor, as we discussed off the record, would like the commission to take, as you just indicated, administrative notice of the report and order in EO 2015-0240 and 0241, as well as the non-unanimous stipulation and agreement resolving MIA issues in those same cases.
And those were also emailed to all the parties prior to the hearing. Mr. Kleiser, do you have a similar objection? Excuse me, with that case?
Given the line of questioning has already been taking place, I will not raise a similar objection.
Okay, would there be any objection to the commission taking official notice of that report and order and its attachment, non-unanimous stipulation? Okay, I see no objection to that, so I will take official notice of those. Okay. Was there anything else that needed to go on the record at this time?
Your Honor, this is Roger Steiner. I neglected to offer into the record the testimony of Lisa Starkeybaum yesterday. I'd like to do that at this time. I believe it has been marked as Exhibits 6 and 7. Direct and rebuttal, I think.
Yes, that's correct. Direct testimony is Exhibit 6 and rebuttal has been marked as Exhibit 7. Was there any objection to those documents coming into the record? Seeing none, then I will admit Exhibit 6 and 7.
Thanks.
Is there anything else before we begin with testimony? Okay, then I believe public counsel can call its witness.
Public counsel would call Lena Mantle to the stand.
There you are, Ms. Mantle. Can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Okay. Go ahead with your questions.
Would you please state your full name and spell your last name for the record?
My name is Lena M. Mantle. M-A-N-T-L-E.
And are you the same Ms. Mansell who prepared or caused to be prepared testimony, direct testimony that has been previously filed or previously labeled 200 HC 201C and 202?
Yes.
And did you also cause to be prepared rebuttal testimony, which has been pre-marked Exhibit 203?
Yes.
Are there any corrections you would like to make to your testimony at this time?
No.
Are the answers contained in those testimony, both the direct and rebuttal, true and correct to the best of your knowledge and belief?
Yes.
If I asked you the same question today, would your answers be the same or substantially similar?
Yes.
At this time, I would offer Exhibits 200 HC, 201C, 202, and 203. Sorry, I did it all at once. I hope that's okay.
That's fine. Do you have, is there any objection to Exhibits 200 HC 201C, which is confidential, and 202, which is the public version? Seeing none, I will admit those. Is there any objection to Exhibit 203? Seeing none, I will admit that.
And I tender the witness for cross-examination.
Is there cross-examination by staff?
Yes, Judge. Good morning, Ms. Mantle.
Good morning, Mr. Kringle.
So I kind of just want to talk to you a little bit about these Schedule 11 fees. Would you agree that the Schedule 11 fee and energy cost issues you brought up in this case stem from and originated in the issues raised by staff in the MIA prudence review case based on the implementation of the demand response programs. Oh, Lena, you're muted. You're muted, Lena.
You're still
Okay.
muted, Miss.
Is
There
it-
you go.
Can you hear me now?
Yep.
Okay.
We're getting a little bit of feedback. Is
You went back on mute.
everyone is still muted? Mr. Kleiser, you're still muted.
That's why. Okay, thank you.
Okay.
For the clarification of the record to explain, Lena Mansell and I are in the same room. We are using one audio input. It will be my audio input, so it will show up on the WebEx program as if I am speaking when she is speaking. And I apologize.
Okay. Thank you.
And let me know if you want to repeat the question, Ms. Mantle.
Yeah,
Would
let's
you
start
please,
again.
Mr. Pringle?
Yeah, not a problem. The question was, would you agree that the Schedule 11 fees and energy cost issues you brought up in this case, this FAC prudence review, stem from and originated in the issues raised by staff in the MIA prudence review case based on the implementation of the demand response programs?
They did not originate in that case. They originated when Evergy did not take the action. That these are as the result of inactions by Evergy. It's the first time I became aware of them, or it was through the MIA case when I saw the testimony written there, but that is not the origination of these. That would be Evergy's inactions was the origination.
All right, so it's fair to say you became aware of it through the testimony from staff in the MIA prudence review.
I cannot say it would necessarily be the testimony of the staff. It could have been when Jeff Mark talked to me about it too.
Okay, but it was through that case?
Yes.
And then would you agree that the demand response program is a MIA program funded through the demand side investment mechanism?
The demand response programs are demand side resources that are available for the utilities' use to cost effectively meet their loads. It is, I do believe we've argued in the past that some of these should not necessarily be MIA programs, but I do believe they are. They don't have to be. Matter of fact, we've had similar programs. I believe KCPL had them back in the 70s, so way before MIA. So they don't have to be MIA programs, but they have been labeled that, and Evergy is receiving reimbursement plus other things through the MIA statute.
Okay, and yeah, the programs we're talking about today, they are MIA programs.
They are programs whose costs are recovered through MIA, yes.
And then, okay, so do you have your direct work papers in front of you, Ms. Mantle?
Just 1 second.
And also, Judge, a good portion of Ms. Mantle's work papers are confidential. My line of questioning isn't necessarily going to be diving into that, but for safety's sake, perhaps we should go in camera for this line of questioning.
I prefer not to go in camera if we're not going to be divulging the confidential information. So I guess I'll ask you again if if you're going to be requiring confidential answers or,
The response that I'm expecting shouldn't be.
okay. Well, then, Ms. Mantle, if you would be cautious in your answers, and if there's something that has been previously designated as confidential, then let me know and we can go in camera at that time.
Okay, Judge.
Thank you. Go ahead, Mr. Pringle.
Thank you, Judge. And Ms. Mantle, do you have those work papers in front of you?
Yes, I do.
Could you go to the Schedule 11 tab?
Okay.
And pretty much just for my clarification purposes, looking at A61, E61, what is meant by the J factor in the context of this calculation?
That is, I believe, the transmission percentage. I must have labeled that one. I got it labeled correctly for West. For Metro, I have it as a J factor, which is typically a jurisdictional allocation factor. But it looks like the transmission percentage, because only a portion of the Schedule 11 costs flow through the FAC, and that's tied to the percentage of purchase power that was modeled in the last case to meet the loads of the utility.
Okay. So yeah, that was what I'm. So is transmission percentage is not a jurisdictional factor.
That is correct.
Okay, that is all I have for you, Ms. Mantle. Thank you so much.
Welcome.
Is there any cross-examination by Evergy?
Yes, briefly, Judge. Ms. Mantle, thank you for coming today. Did you hear that we were successful in settling your IRP issue yesterday?
I participated in that, so yes,
Oh,
I'm aware of
okay,
that.
very good. Well, the good news is that takes about 65% of our cross away today, so we don't have to talk about those issues. But I would like to talk to you about the issue that's currently in front of the commission. Do you have your direct testimony and your sir rebuttal testimony there?
I have my sir rebuttal up. I can get my.
Oh, well, I'm just going to ask you one or two questions on your direct, so maybe we can do that without having you pull it up. But
I actually found a hard paper copy.
okay,
They're rare,
good.
but you can find them sometimes now.
Very good. Well, I'd like for you to turn to page 19 of your direct testimony. And
Okay.
if you look on line 20 of that testimony, you say OPC supports the staff's position in the Mia Prudence case that it was imprudent for Evergy not to call on its demand response programs to reduce the cost of energy for its customers. Is that right?
That's what that says, yes.
In that direct testimony, did you suggest the appropriate number of calls that should have been made during the MIA 2 or during the prudence period in this case?
I did not.
Let's turn on to page 14 of your sir rebuttal testimony. There at lines 5 through 8, if you're there on page 14, you suggest that Evergy should have called 14 curtailment events related to the residential demand response program and 9 curtailment events for the commercial and industrial demand response program. Is that correct?
Yes.
In answer to Mr. Pringle, I think you indicated that you became aware of this issue when you talked to Dr. Mark related to the Mia Prudence case. Is that right?
Yes.
When you prepared your direct testimony or when you talked to Dr. Mark about this issue, were you aware that the company, the staff, the public counsel, and others entered into a stipulation and agreement in 2019, which required that the company call 5 demand response events per jurisdiction during the summer of 2019 for the residential demand response program?
I don't believe that I was aware of that at that time.
Okay. Do you have a copy of the stipulation and agreement extending MIA 2 in EO 2019-0162?
I am going to hand her a physical copy.
Oh, very good. Thank you, sir.
I just wanted to make sure that people on the screen knew what I was doing.
Yes, I have that in front of me.
Let's turn to paragraph 4 to start with.
All right, Your Honor. It's at this point that I'd like to raise my objection.
Okay. Let me pull up that agreement first. Sorry, I was having difficulty locating it. Okay, that's the 0132 case number again? Yes.
Yes.
Okay, now go ahead, Mr. Kleiser.
If you have the stipulation in front of you on page 6, under the general provisions, subparagraphs 18 and 19. Under paragraph 18, it states this stipulation is being entered into solely for the purpose of settling the issues and adjustments in this case explicitly set forth above. Unless otherwise explicitly provided herein, none of the signatories to this stipulation shall be deemed to have approved or acquiesced to any rate-making or procedural principle, including without limitation any cost of service methodology or determination, method of cost determination, or cost allocation or revenue-related methodology. Under paragraph 19, the stipulation is a negotiated agreement or settlement, except as specified herein, the signatories to the stipulation shall not be prejudiced, bound by, or in any way affected by the terms of the stipulation, A, in any future proceeding, B, in any proceeding currently pending under their separate docket, or C, in this proceeding should the commission decide not to approve the stipulation or in any way condition its approval of same. No signatory shall assert the terms of this agreement as a precedent in any future proceeding. My objection based on these terms is that this stipulation is not relevant to the present case because the present case is a separate proceeding, and therefore the stipulation does not bind on the present proceeding under its own terms and should not be cited to under its own terms.
And Mr. Fisher, you have a reply?
Yes, in response, Judge, I would say this is highly relevant to the proceeding that we're involved in today, especially on the issue of how many curtailment events should have been called during the summer of 2019. As Mr. Kleiser pointed out, paragraph 19 says, except as specified herein. herein, if you go to paragraph 22, it says, if approved and adopted by the commission, this stipulation shall constitute a binding agreement among the signatories, which of course included the public counsel and staff. The signatories shall cooperate in defending the validity and enforceability of this stipulation and the operation of this stipulation according to its terms. I think if we go forward with our cross-examination and our discussion with Ms. Mantle, the commission will see just how highly relevant this whole topic is.
May I respond, Your Honor?
Go ahead, Mr. Kleiser.
This is a binding document with regard to the MIA case that was settled. We are not in the MIA case. We are not in the MIA prudence review case. This is an FAC case. It is a separate case. The agreements that the company reached to settle MIA do not bind in the FAC. Even if the company agreed to call 5 events in MIA, it still had an obligation to act prudently with regard to the FAC that existed independently despite the agreements reached in this negotiated settlement, per the terms of the settlement itself.
Judge, I think that goes to the merits of the whole issue, but I would suggest this is highly relevant, and the company felt it was bound by the terms of this agreement. We thought the public counsel and staff were too. I'd like to visit with Ms. Mantle about that particular topic here, and it won't take too long, but it's highly relevant to this docket.
Okay, I understand. Again, these two cases have been somewhat intertwined, but I think in order to sort them out and make sure that we have the right information in the right case, that we need to hear this line of questioning. And I think that the commission does need to have a copy of that agreement and order in this case so that it can determine the weight to give the testimony on these issues. So I'm going to overrule Mr. Kleiser's objection, and I'm going to go ahead and let Mr. Fisher do this line of questioning, and I would like to include that report and order and stipulation in the official file so that the commission can then sort out again where this testimony lies on the MIA scale, where it lies on the FAC scale. So,
Judge, then would it be appropriate for me at this point to ask that the stipulation and agreement and the order approving the stipulation and agreement in those cases be taken official notice of?
yes. And once again, Mr. Kleiser, I'll let you make your objection if you have.
Do you need me to repeat it, or can I simply stand on the objection?
You can stand on the objection, and
I would like to do so.
That is noted and overruled. And is there any other objection to the commission taking notice of those documents? Okay, then the commission takes official notice of those documents. Go ahead with your line of questioning, Mr. Fisher.
Thank you very much, Judge. Ms. Mantle, would you turn to page 2 on the stipulation and agreement? There's a paragraph 4 where it states, in light of the foregoing, the signatories agree to the following terms and conditions. Is that correct?
That's what it says.
Now, is it correct that the Office of the Public Counsel and the Commission staff were both signatories to the stipulation?
Yes.
What is the date of that stipulation? Is it February 15, 2019?
Yes.
Let's turn to page 3 of the stipulation, paragraph 7. In paragraph 7B, does it state that for the programmable thermostat program, the company will call 5 demand response events per jurisdiction during the summer of 2019, June through September in parentheses.
Yes, you read that correctly.
So is it correct to conclude that the Office of the Public Counsel and the Commission staff recommended to the Commission on February 15, 2019, that for the programmable thermostat program, the company will call 5 demand response events per jurisdiction during the summer of 2019?
That is what this document says.
Is it your understanding that the review period for this case, the FAC prudence period, is June 1, 2018 through November 30, 2019?
That is what it is for Missouri West, for Evergy West, for Evergy Metro. The FAC prudence period is for July of 2018 through December of 2019, so they don't lie on top of each other exactly.
Okay, that's fair. But for both of those time periods, the review period for the FAC prudence review would include the summer of 2019. Is that right?
Along with the summer of 2018, yes, both summers.
Okay, good. So the Public Counsel, the staff, and Evergy recommended to the Commission in that stipulation that we're discussing that for the programmable thermostat program, the company will call 5 demand response events per jurisdiction during the summer of 2019, correct?
Correct.
What's your understanding of what the term per jurisdiction would mean? Would that mean for GMO and for KCPL, both?
I'm going to object that it calls for a legal conclusion. She's being asked to interpret the terms of a contract.
I
Judge,
think he asked what her understanding of the term was, so I will allow it overrule.
While the document does not exactly say what jurisdiction means, company is defined as KCP &L, Greater Missouri Operations Company, and Kansas City Power and Light Company. So that's from my reading of this document.
so it's fair to conclude that, at least as you understand it, we're talking about both companies would do 5 demand response calls, right?
From 7B, they would do, this was requiring, or the company agreed to do 5 for the programmable thermostat program. So that would be the residential and the small commercial programs.
Yes. Do you happen to have the order approving the stipulation available to you?
Yes, I do.
I'd like to refer you to page 3 of the order. In the ordered sections, is it correct that the order section states on page 3, the commission orders that, and then the very first ordered section says, the stipulation and agreement regarding extension of MIA 2 programs during pendency of MIA 3 case filed on February 1, 2019, which is Exhibit 1 to this order, is approved. Does it say that?
It does.
And then does it go on to say the next phrase, and its signatories shall comply with its terms? Is that correct?
It does.
And was one of the signatories to that agreement Evergy?
It was the company that was defined as Kansas City Power and Light Company and KCP&L, Greater Missouri Operations Company, which is currently known as Evergy.
Okay. And one of the signatories was the Public Council?
Caleb Paul signed for the Public Council.
And one of the signatories was the commission staff?
Yes.
And according to this ordered paragraph, the signatories shall comply with its terms, correct?
That is what it says.
Were you in the hearing when Mr. File testified?
Yes, I was here.
Did you hear him testify that both Evergy companies called 5 demand response events for the programmable thermostat program during the summer of 2019?
I heard him say that, and I heard him say that had they wanted to, it was
I
his
think you've
belief
answered
that
my
Evergy.
question. The stipulation required that the company to present data to the DSM advisory group following the 2019 season, detailing the customer participation rates, including the opt-out percentage and participation duration times for the DSM curtailment events. Is that your understanding?
Can you point me to where it says that in the stipend agreement?
Yes, let's go back to the stipulation and agreement on page 3, paragraph 7B. I already read the first sentence from that, but the second sentence says, the company will present data to the DSM advisory group following the 2019 season, detailing the customer participation rates, and then in parentheses, for instance, opt-out percentage, participation duration, into parentheses, during each demand response event conducted in 2019. Is that right?
It does say that.
Isn't it true that residential customers may choose to opt out of demand response events by overriding the curtailment by adjusting their thermostats to a level that they feel is more comfortable?
I believe that the current tariff says that. Now, the tariff that was in effect, or it may have been the large customers that could only opt out once. But there is some confusion to that. But customers could opt out. They could walk over to their thermostat and turn it up.
In paragraph 7B of the stipulation, is that what you would understand the opt-out percentage to be about?
It could be. I wasn't there for the discussions. I have not been involved in these, so I don't know for sure, but it makes sense that it could be.
From your perspective, why would it be important for the public council to know what the opt-out percentage would be? Or the advisory group?
Opt-out customers are free riders. They're customers that do not want to take from the company, but not provide what they were supposed to in return.
So it'd be important to know how the program was working and whether people were deciding they didn't really want to be a part of it because the company was controlling the air conditioning load too often.
That should be a part of the evaluation of any and every demand side program.
Because you realize, right, that customers don't like to have their air conditioning load curtailed very often, correct?
There would be some customers that way. Some customers welcome the chance to help Evergy or their utility company to reduce demands on peak days. People, many who took that money expect to be interrupted. If they're not, they're wondering why Evergy's spending their money on this. And it's not Evergy's money, it's the customer's money.
Do you happen to recall what the financial incentive is to participate for a residential customer?
I believe it's $25 a year, regardless of how many events are called, 1 or 15 or none.
So for $25 a year, you allow the utility to control your air conditioning load during the hottest days of the year. Is that right?
That's what the intent of the program is, yes.
Let's go back to 7B and the stipulation. Does it say that for the programmable thermostat program, the company will call at least 5 demand response events?
No, it does not.
If it had been the intent of the parties to have the company do a lot more than 5, wouldn't you have expected it to say something like that?
I was not part of those conversations with that negotiation. I cannot say what was intended by the parties.
And Miss Mantle, when you made your recommendation in this case, in your direct testimony, you weren't even aware of this provision, were you?
I don't believe that I was.
I was intrigued by your counsel's opening statement because he always comes up with great analogies. And the one he used this time was about a red button, where it reminded me of the Staples commercial where you have the easy red button and you just press it. Would you agree with me that it's important to know not only how many times to push the red button or to call the curtailment, but it's also important to know when you're going to do it and under what circumstances?
You could have general circumstances and then you can have very specific. I don't think that you want to narrow yourself down to specific, but to the two that are included in your tariff sheets of reliability and economic reasons, those general and designations I think are important.
You recommend, I think, in your SIR rebuttal that the company should have done 14 curtailment events. Is that right?
Yes.
Just in relation to the analogy, should the company have just pushed the button the first 14 days of June?
No.
Why not?
Well, there's several reasons. If you want to try to reduce peaks in each of the 4 months that you have that program available, you can only do it June through September. To reduce the SPP Schedule 11 fees, the more of those peaks that you can reduce, the cheaper that is, or the more money you save the customers. And you also have the objective of the program to reduce the summer peak, which typically does not happen until late July or early August. So to use all of those in June would be foolish.
So it's important to know not only how many times to push the button, but also very much what the circumstances are when you push that button, correct?
Yes, if we got to September and that button had not been pushed yet, then every time the market price was positive, you would be saving customers money. And therefore, you should utilize as many of those events as you can before the curtailment season is over. And I limited it to 14, so there would be one still available when there's operational constraints.
Ms. Mantle, is it your understanding too that I think sometimes it's referred to as arbitrage of the day ahead price, that the company they don't always win, right? They can guess wrong and they can actually incur a loss. Is that right?
And that's right. And every time they don't guess at all, they are wrong.
And
They're
every
wrong,
time-
they're losing money. Customers are paying more.
And would you agree with me that every time they guess wrong, that those losses flow through the fuel adjustment clause?
If they do nothing, the costs flow through the FAC clause.
That wasn't my question. My question was, if they guess wrong, those losses flow through the fuel adjustment clause, correct?
That's correct.
Let's go back to paragraph 7B of the stipulation and agreement.
Okay.
Is there a provision in this paragraph that says, notwithstanding the provisions of this paragraph, Evergy will call 14 demand response events during the summer of 2019 with the goal of minimizing SPP fees?
No, that was a MIA case.
Judge, I think that's all the questions I have. Thank you very much, Ms. Mantle.
Thank you. Okay, at this time, are there questions from any of the commissioners? I have a list still from that has been compiled, but if any of the commissioners have specific questions that they haven't been able to get to me, this is a good time, or you can ask after I've asked my questions as well. Not seeing anybody speak up, so I'm going to go ahead and ask some of the many questions I have. Okay. So I'm just going to start here, Ms. Mantle, and I apologize if I repeat anything or myself. I'm trying to compile from several different lists of questions. So first I have some questions just to make some basic questions just to make sure that the record's clear about peak demand and demand response events, calling demand as response events. When does peak demand normally occur?
Well, there is an annual peak demand, and for both of these utilities, that typically occurs in the summer when there's been several hot days in a row, an extreme temperature event, usually late July, early August, about 4 p.m. in the afternoon typically. And the other summer months around that will have peaks about the same time of the day, may not be as high. And then you can have peaks in a week and in a day. So, a peak is just a maximum over a defined time period. So you can have a peak for just about any time period.
And what factors do you look at in projecting or forecasting peak demand?
The biggest factor is weather, and it's not necessarily just the weather on a single day. It has to do with, again, have there been several hot days in a row? You could have a hot day in June, a day where the maximum temperature is 100. You will get a different response than if you have a day with 100 degrees in August, where there's been days before that between 90 and 95. So it's accumulation. It has to do with the time of the year. It has to do with the temperature mostly. And then there's other things that affect load that you cannot guess. There's just always things. People are unpredictable.
And are there other factors that, besides the weather, that come to mind?
The day of the week. Typically, peaks only occur on weekdays, and I can't necessarily say one day of the week over the other. So that is also a factor. Again, the time of the year, the season, but weather is the biggest driver.
Okay. And is that the same? What factors do you believe should be considered in deciding when to make a curtailment call? Is it the same? Is the weather the biggest factor?
Weather, and when you're buying from the SPP, it's not just necessarily, well, I guess if you're going to reduce Evergy's peak, then you need to look at the weather in the Kansas City region. If you're looking for what kind of market prices, then you look at the whole SPP and what may be happening there. But if you're reducing the system peak of Evergy, you should look at the weather, not necessarily just the temperature, but if there's a front that's going to be passing through, all the weather in general is the biggest driver.
And I'm not sure we've even defined the term SPP. We talk about that a lot. That's the Southwest Power Pool. Is that correct?
That is correct. It's a regional Go ahead.
No, you finish.
It's a regional transmission organization that Evergy belongs to. And I'm talking on general terms. I'm sure we could get into, there could be more details where these generalities don't apply. But Evergy pays SPP for every megawatt of load of its customers. And it sells its generation to SPP. The generation is not tied to Evergy's load. It is tied to the market price and what Evergy expects the market price to be. So the load of the customers does not control what generation Evergy has online. Therefore, it makes it important to reduce that load because they have to buy every hour enough to cover that load, regardless of what they have generating.
And the territory of SPP includes what? How far-reaching is
it
that?
may have some, yeah, it may have some Canadian providences. I don't know, but it's from north to south through the Midwest of the country to the mountains. Kansas City Power and Light's about as far east as they go, or I guess it would be Evergy West, what used to be GMO.
When the company's customer usage exceeds its generation, it purchases power from SPP, correct? That's what you were just explaining.
It purchases power from SPP for every hour, whether it has enough generation up and running or not.
And that's considered purchase power.
Typically in the old, back before they purchased from the SPP, yes, that would be considered purchase power. And we typically talk it that way in rate cases because we have models that say this is what the generation would be, and so we need to purchase more than that. But so it is called that. That's sort of an old term. I don't know what you call it now. The utilities tell me that, you know, we're in a new new realm here that no longer applies. They purchase all of their load from SPP.
During peak demand, power prices are generally higher. Is that correct?
Assuming that SPP's peak is about the same time as Evergy's, yes. That if Evergy peaks at a time different than SPP is peaking, then the prices won't miss. They're often high other times than just peak, but generally, yes.
Do the two peaks, does Evergy's peak and SPP's peak generally align, or are they often different?
I have not looked at that, so I really can't say.
Okay. When a utility's power needs exceed its generation during a peak demand period, a utility with a demand response program can call an event and thus reduce the amount of power it must buy, correct?
That applies to any hour that calls the demand response program. That is correct.
So in your testimony, your point was that Evergy's demand response programs allow it to call an event in which it will cycle participating customers' air conditioning units temporarily to reduce demand during peak periods and thus reduce its purchase power costs. Is that accurate?
I wouldn't necessarily say peak periods. I'd say, peak periods are important. That's what will reduce the SPP Schedule 11 fees. And then also the system peak, because the Evergy needs to show the right amount of capacity for SPP. But also looking at what the prices are, there's day-ahead prices, and looking at any hour that they can reduce the load, then they save money from, SPP doesn't charge them as much. So it's not just the peak. It would be any hour that the price is above zero, more or less.
Okay, so your basic position is that Evergy should have called more curtailment events. Is that correct?
Yes, they had the resource available to them, and they should have used that resource.
And you said earlier that you were present when Mr. File testified, and he called over the dates that the company had called curtailments for 2018 and 19. Did you agree with the dates he listed?
I have no way to know, and the fact that we're having trouble pinning those dates down, I can't say.
Okay. Do you have specific additional dates that you believe that Evergy should have considered curtailment? Are those in your testimony?
I didn't specifically provide those. All the data that I really had to work with was the 5 highest cost hours in the summers, and those are a good start. Mr. File also had several other things that should be considered, and I didn't understand his retail cost. But other than that, I agreed with him. That information was not available. And I used those 20 hours knowing that I was only capturing a portion of the number of hours that were actually available to be curtailed. And so it was a very conservative number. It wasn't like I picked 60 hours or for the residential and commercial or 80 hours for the business. That's the demand industrial. That's how much could have been chosen. But I didn't have more than those 20 hours, and I knew I wanted a conservative number. I wanted a number that was representative of what a realistic number. And you got to remember too that this number had Evergy reduced its energy use. The jurisdictional factors for Kansas City or Evergy Metro would have been lower, and all of the FAC costs would have been reduced that were passed through to the FAC. So while I did not capture every single cost, I did not capture the total number of hours that could be captured. I did not capture that reduction in the FAC cost for the jurisdictional factor. I feel my number is a good representative number. It's probably the actual one would be much higher. And so I am comfortable with my number as being a good number for what customers paid that they shouldn't have.
Okay, so let me just clarify that just a bit. So why did you choose the 20 hours instead of the maximum 80 hours or 60 hours for residential?
Well, the most obvious answer is that's all the data I had. And I was okay with using that because I did not want to go out and cherry pick and find the highest price every hour through the summer months. That wasn't my objective. My objective is to get the commission a reasonable estimate of the impact.
Okay. I'm looking through my questions here. I think you've answered some of them preemptively. So let's see. I may be backing up just a little bit, but can you explain, well, let's see. Would you agree that there are a number of ways that your energy savings imprudence adjustments could have been calculated?
Yes.
And so I think you've already said this, but just so that it's more clear, why should the commission accept your method of calculating the energy savings adjustments as appropriate in this case?
To get the exact number, probably there's just no way to do it. But when you, because really what needs to be done is to go back and look at some parameters about what would a reasonable person do, when would they call that, what time of the year is it, do we need to call now, should we save some for later? All of those types of decisions would, if you're going to be accurate, you'd have to go back and look at every hour in those 4 months, which, you're talking over 3,000 hours. So, this could get so weighted in data and assumptions that, you often hear, don't let perfection be the enemy of good enough. There can be so many adjustments made to each one of those hours and so forth. I picked something that I thought would be conservative and something that's reasonable.
Okay. Let's look at your SIR rebuttal testimony on page 18. You're discussing staff's data request number 41. Can
Yes.
you explain to me what staff's data request number 41 was? And again, if I'm asking something that's confidential, please don't give me the confidential information.
What staff asked for in data request 41 was the hourly prices, day-ahead market prices for Evergy, both Metro and West, because they do have different prices, for the 5 highest priced hours in those months. So for each utility, for the months of June, July, August, and September, the month or the hour and the market price, the 5 highest for each month. So there were 20 data points for 2018, 20 for 2019, and then for each utility.
And just to clarify again, this was data request 41 in this case, correct?
Well, there was, since they've been consolidated, yes. There was one in Evergy West case, there was one in Evergy Metro case.
Right, but it was not part of the MIA case.
That is correct.
Okay. Is that?
Well, wait a minute.
I'm sorry.
I said yes, but I'm not for sure on that, Judge. I didn't even put that in my testimony.
Do you have a copy of that data request?
It would take me a minute to find it, but I could.
Is that anything that's overly large, or is it a spreadsheet, or do you know what format that is in?
I believe it was attached to Jay Lubert's rebuttal testimony in this case.
Oh. Okay. Okay, so you reviewed the 5 hours in each summer month with the highest market price for both 2018 and 2019, correct?
Correct.
And that was what was in the response to staff's data request 41?
Yes.
Okay. Would it have been more appropriate to base the energy savings adjustments on SPP's forecasted prices for the highest 5 hours each month?
I don't know that they put out a forecast more than a day ahead. In real time, I think you would look at what data was provided to you for projected market. I mean, I'm assuming Evergy has its own department on that. They've got some really smart people that should be looking at those. But I don't know that we have that in retrospect.
Okay. Did public counsel, or do you know if staff asked if that information was available?
Public counsel didn't. I don't know if staff did.
Okay. Can you explain how SPP forecasts energy prices for its day-ahead market?
In general terms, because I'm sure it's very, very detailed, the generation members, which Evergy are load serving and they have the generation, they bid into the market the availability of their units. And then they also say what they think the load's going to be. So taking those, they see where load's going to cross and how much generation is going to need and what is that marginal price of that marginal unit. And that's the market price. That's my understanding of how SPP sets the market price. And it's different for different nodes because you've got transmission constraints. So that's one of the reasons why Evergy West market price is different than Evergy Metros, is because of the transmission constraints.
Okay. Is weather forecast as an important factor in forecasting energy prices in the summer?
It is in the summer and the winter.
Does SPP, do you know, does SPP rely on weather information from NOAA?
I don't have any idea what they rely on.
Okay. Do those hours of highest market price correspond to the hours of peak demand for Evergy Missouri Metro and Evergy Missouri West?
More often than not, but they may not always. There may be some transmission constraints. A power plant may be down for an outage that changes these things. Wind may not have been what they thought it was going to be. There's a lot of factors that typically you can say the weather drives the most consistent high market prices.
Did you have the information necessary to calculate a prudence amount using the 20 peak demand hour market prices?
Given unlimited time and unlimited data, I probably would have liked to have calculated something different. But this is, and too often an analyst gets paralyzed by wanting to do the best and only having a little bit of information. After doing this, I did think about that. You know, what would I have preferred something else? Then probably. But I am content with these numbers because they are conservative and they recognize that there's a lot of things that I couldn't account for, that you couldn't account for even if you had all the data.
Okay. Again, on page 18 of your SIR rebuttal at line 14, you talk about the amount of DRMW available. Can you just explain what you mean by those available in these 20 hours?
The megawatt available is how much demand reduction the EMMV people said was available, or how many people had signed up. When you sign up, then they can say how much of your load is available to be reduced. And so the megawatt available would be a combination of all the participants, how much load they could reduce in that hour.
Okay. So is it correct that savings that resulted from the events Evergy actually called in 2018 and 2019 have already flowed through the FAC?
Yes, and I did last night look at the dates that were given yesterday, and my work paper, and that was about 55,000 of my total 760,000. So that's what I calculated. Not all those days were in those top 20.
Is it accurate that your imprudence amount then reflects an additional 20 hours above the 20 hours that were actually called events?
Trying to remember, there were 5 events in 2019, and just I think 1 in 2018, 2 in 2018. not all those hours were in the data that I had. Again, there's a lot of, what I have was 20 hours, and they could call 60 to 80 hours. So the number is still, I'm still comfortable with 760,000, even though a few of those hours really were reduced because of I'm using 25% of the total hours available that could have been called.
I'm having trouble locating the entire DR41 as being attached in the testimony. You said that that included the data points, correct? The response.
You may not be, it probably isn't labeled that way. Let me pull up his, see if I get any errors, Lubert.
If I may, Judge, it's not in Mr. Luber's testimony, but also there isn't. I looked it up on EFIS, and there's no confidential information in it.
Okay, you're saying, you said it's not attached to Mr. Lubert's testimony? I'm sorry, you cut out there
No,
just a little bit.
it's not attached to his testimony, but I mean, it's referenced, but the actual response itself is not attached. I have found the response, though, and there is no confidential information inside it.
Okay. Would any of the parties have an objection to the data request number 41 and its response being admitted as an exhibit?
Can we look at it first? I don't know what it is either, Judge.
Yeah, we don't have a copy in front of us right now.
Okay. Okay, can you all take a look at that, and maybe we will address that along with the additional tariff records at the end, or including it as a late filed exhibit also. I just want the record to be clear, since there's been a lot of testimony about those responses.
Yes, we can do that.
Yeah, we can look at it and say whether we object or not in our filing tomorrow. Is that what you said, Judge?
Yes, yes.
Okay.
Okay. Thank you. Okay, let me see. Switch gears here just a little bit. Ms. Mantle, can you explain simply what Schedule 11 in SPP's tariffs are?
My understanding is that it is the schedule that allocates the cost for the big transmission projects and upgrades to projects. Excuse me. Out all across SPP, this is the big number, the big cost from SPP as far as building and upgrading transmission. So it's regional projects and how they're allocated, and that's done through Schedule 11.
Okay, and do you know how those Schedule 11 costs are determined?
No, I do not. The costs themselves, no.
Okay. Do you know how SPP determines Evergy's load share percentage?
I would assume it's, and from the work papers, it's a total of, they look at what's the average of the 12 monthly peaks for all the utilities, and sum all the utilities peaks up to get one for SPP, and then each utility is a percentage. Their 12 CP divided by SPP's, and that's CP coincident peak. So what they're doing is taking each individual's utility number divided by the total.
And do you know what Evergy West and Evergy Metro's SPP load share percentages were in 2018 and 2019?
No, I do not.
Okay, I think I asked that of Mr. File yesterday, and he was going to provide that information later, so. If Evergy had made additional curtailment calls during the review period, how would it have affected the Schedule 11 charges?
What I call the 12 CP, that's an average of the 12 monthly peaks. For every peak that was lower, that goes into calculating that average. So if the monthly peak, and for these programs, it's only June through September. So for each peak that was reduced, that 12 CP for that utility is reduced, therefore reducing its percentage of the total. And then that's applied to the next year.
And do you have the information needed to know what load shifts would have been required by Evergy in order to impact its SPP load share calculation?
Theoretically, a shift of 1 megawatt would impact it. So any impact, even if they'd only shifted one more peak, it would have impacted. It doesn't have to be all 4 peaks. They don't have to get every peak right, but if they can impact more than just the summer peak, then they reduce that Schedule 11 fee.
Do your proposed adjustments to energy costs and SPP Schedule 11 fees assume the maximum number of calls to Evergy's demand response thermostat programs during the prudence review period?
No, it does not.
And I apologize if you've already told me this, but go ahead and explain how you calculated your adjustments again.
I had those 20 hours of data for each utility for each summer, and it would be the demand response amount available, and it was different for 2018 than 2019. And so I assume that they did achieve that total amount for each of those hours. So since you've got megawatts and you've got dollars per megawatt, you multiply them together to get an hourly cost of not calling that demand response program in that hour. And then I summed that up. Now for for Evergy Metro, I did not include the month of June in 2018 because that's not in the FAC prudence period.
Okay. Okay, now I'm going to back up to the beginning of your rebuttal testimony at page 2. Are the adjustment amounts on page 2, are those adjusted for the 95% sharing mechanism in the FAC?
No, they are not. And so they should be reduced by 5% if a prudence amount is ordered. So those numbers should be reduced by that 5%.
Okay, so, and it's been a minute since I've looked at that, but in Mr. Carlson's rebuttal testimony, on page 22, lines 11 through 14, he cited some additional reductions. Are those reductions appropriate?
That was Carlson's rebuttal.
Carlson's rebuttal at
I'm
page
handing her a
22.
physical copy of Carlson's rebuttal.
Okay. Judge, where was that?
Page 22. Yeah, it's at the very end there at lines 11 through 14.
Those are the same numbers that are in my testimony.
And then he
rebuttal
says
testimony.
those need to be further reduced by applying the appropriate transmission percentage applicable to SPP transmission service costs and any jurisdictional adjustments, as well as the 95% FAC sharing mechanism adjustment. So we've talked about the 95%. Are there other adjustments that would be appropriate?
The applicable transmission service cost, I'm assuming he's talking about I'm not for sure what he's talking about there. I can't really say. The other thing is the jurisdictional adjustments. I thought about that and did not apply a jurisdictional adjustment to these because this is a resource that Missouri customers are paying for. This is not, Kansas customers should not get any of this benefit. It is just a fairness issue. And it would have reduced the amount of energy and changed that jurisdictional allocation factor. So I did not apply a jurisdictional factor to these, and I don't think one should be. Missouri customers should get the benefit of this. Kansas customers, other jurisdictional customers should not get the benefit of these programs that the Missouri retail customers are paying for.
So can you just explain to me what a jurisdictional adjustment would be then? I mean, how does that work?
With with Evergy Metro, you have the Kansas portion of the load is one jurisdiction, and then you also, I'm not for sure whether they have any wholesale customers or not. So typically with utilities, a jurisdictional allocation is done so that we can apply just the cost and savings to Missouri retail customers. And the key word there is retail. For Evergy West, while they don't serve customers in another state, they do have a few wholesale customers. And in a rate case, typically we look at all the costs, we don't separate them out, and then we apply a jurisdictional factor to them. And that's what we do in the FAC too. It's meant to say the Kansas customers cause some of these costs, and so Missouri customers should not have to pay for them. And in this case, all of these costs are being paid for. The demand response program is a Missouri program. And so I did not do a jurisdictional allocation to them. That could be directly assigned.
Okay.
Your Honor, I apologize. I don't want to interrupt your flow, but if
Yes.
you'll give me 5 seconds, I'd like to address a potential noise problem we might be having over here. I don't know if it's picking up on our audio, but we've got some people outside the office. So can you give me?
Okay.
I'm sorry.
We'll pause for just a second.
I'm very sorry to have interrupted the Commission's question.
That's fine.
Please continue.
Ms. Mantle, can you explain, excuse me, can you explain why the energy sales adjustments amount why the energy sales adjustment amounts changed from those included in your direct testimony.
I assume that Mr. Carlson was correct. He's much closer to the data than I am.
Okay. So you just used the his numbers, or did you have new data that was available?
I just used his numbers.
Okay. So did you have his work papers that showed those calculations and the source of the data, or?
Honestly, I just took the numbers out of his testimony.
Okay, no, that's
I don't
what
know
I need
whether
to
he
know.
provided work papers.
Okay. Okay, I've got just a couple more straggler questions for you. These are some of the same questions I asked the other witnesses yesterday. Okay. What benefits does the company experience when designing a demand response program within a MIA program rather than offering the DR program independent of the MIA program?
I am not intimately familiar with MIA. My general understanding is they get cost recovery between rate cases, so they can change. It's not immediate, but pretty close to immediate cost recovery. And then if they meet their goals, they get more money, and then they also get a return on what they spent on that program.
Okay, and again, I apologize if we've already covered this, but I'm just going to ask it the same way I posed a similar question to Mr. Lubert yesterday. You may recall that the company witness, Mr. File, was asked about the number of demand response events called, and we discussed that earlier as well. Can you determine or recall if the number, if the 5 events was the necessary number of events to call in order for the program to meet the cost effectiveness of 1 for the program? Or are you familiar enough with MIA to know that?
I'm not familiar enough with MIA, and I don't know what happened in that case.
Okay. All right. I think that answers those. Oh, I have one more for you. When Mr. Pringle was cross-examining you at the very beginning, you said costs that go through the MIA, or you said that the costs go through the MIA. The do you recall which costs you were referring to?
The cost of the program, the incentives paid to the customers, and just the administrative cost. All of that, just like a power plant is, the capital costs are recovered through general rates, the cost of those programs are recovered through the DSIM.
And then are there costs that flow through the FAC?
there are not costs of the program. The costs that impact the FAC is just as if you used if you had a coal plant out there and you said, up, we've taken care of 1 hour, let's shut the plant down. That affects the FAC cost. That's the same thing. This is a demand-side resource. It should be treated the same way as a supply-side resource. All of these affect each other. None are done in a silo. The resource planning, MIA programs, all of that affect the fuel cost. And so, therefore, I mean, we've tried to separate this case into MIA and FAC, and the truth of it is they just did not use this resource in a manner where they even tried to come up with savings, energy savings, and that impacts the FAC.
So what flows through the FAC is the savings in purchased power.
Yes.
When a demand response program is utilized to save energy that needs to be purchased. Is that correct? Did I say that right?
Yes.
Okay. Okay, I think that is all the questions I have. I hope I got all of the questions. I'm just gonna, were there any other commissioner questions? Just gonna, if anybody is able. Okay, I don't hear anybody trying to get on.
None
So,
from me, Judge. I'm good.
oh, thank you, sir. I know some of the commissioners most of them have been funneling their questions through me because of connectivity and the other issues. So I hope I got everyone's questions. All right, is there further? Well, you know what? This might be a good place. We've been on the record for almost 2 hours. This might be a good place. So don't take this opportunity to come up with more questions to ask Ms. Mantle, but I think we'll go ahead and take a short break. Let's break for 15 minutes and come back at 11:05. We can go off the record.
Thank you, Judge.
curiosity, could you hear the noise being picked up in the background of our audio feed?
No, I couldn't hear it. So, but I appreciate you preemptively addressing it.
I'm sorry, there were some people talking outside our door. I wasn't sure if they could be heard, and I just wanted to make sure they weren't being picked up.
Yeah. Sorry, Lisa, you had something else?
Yes, just a reference, Dr. Mark. What was the first name of that gentleman you guys referenced in her testimony?
Oh, it is Dr. Mark is his last name. It's Marke. Is that correct?
Yes.
Yes. Oh, my
Okay.
video's not on.
She mentioned his first name. What is that?
Oh,
Jeff. Geoff.
Okay, thank you so much.
Good thing you asked.
And Judge, when we go back on the record too, there was a question you had asked about forecasted day ahead prices and if staff had requested that information. I have an answer for that too, if you'd like it.
okay.
So wait, should I wait till on the record or?
Yeah, go ahead and wait till we get back on the record,
Okay.
which I think everybody's back. Is Miss Mantle back?
She is, but her screen's not on.
Okay.
Give it a second.
Yeah, I'm trying.
There she is. Okay, I think everybody's back. So we can go ahead and go back on the record. And I think the internet broadcast has been unmuted. All right, we are back from our break, and over the break, there were a couple of things that came up. So let's address Mr. Pringle. You had some information.
Yes, Judge. There was a question from the bench to Ms. Mantle about if she was aware if staff had requested any forecasted day ahead pricing from the company in the context of the FAC prudence review and the MIA prudence review. Staff did not. Also, staff is of the belief that those kind of prices kind of originate from SPP and that they don't provide those.
Okay. All right, I need to think about if we need one of the witnesses to put that information on the record.
If need be, after Ms. Mantle, I can throw someone up. It came from the witnesses in this case, and I can throw someone up there if need be to put it on the record through that.
Okay. And then we also had some more information about DR 41.
Yeah, I have it. If the parties are okay, I can make sure to file it as a late exhibit.
So, Judge, this is Roger. I think we're thinking that it's DR 42 that has the 5 highest LMPs for each month.
Okay. But
I
DR
would
41.
offer that
Go ahead, Mr. Kleiser.
I would simply offer that the commission address the question directly to Ms. Mantle on the record.
I found them in the MIA cases, EO-2020-0227 and 0228, and in that case they were DR 42. So I guess I would correct my testimony to that. If Mr. Pringle is aware that they were in the FAC case, that could be where I got my 41. But I found them in the MIA case under DR 42. In each of those cases, the same DR.
Okay, and would there be any objection to that DR 42 coming into the record? Shall we go ahead and have it submitted, and you can make your formal objections with the objections to the tariff pages? Or do you know now that you don't have an objection?
We can certainly do that, Judge. We'll include DR 42 from the MIA case in the filing we make tomorrow.
Okay, that will work. So we will again we'll just hold the record open for that DR, and I'll get your responses to it.
Yep. It'll be the question and the answer.
Appreciate that.
And then this might be a good time. The reference was made to the load ratio shares, and we have that information. Should I put that in my filing tomorrow as well?
Yes, I was gonna bring that up at the end.
I will do that.
Okay, so I think then with that, unless there's something else, we're ready to begin with further cross-examination of Ms. Mantle. So is there further cross-examination based on commission questions from staff?
Yes, Judge. Yeah, good morning again, Ms. Mantle.
Good morning.
So you faced a lot of questions today about number of events that were called or should have been called, correct?
I have, yes.
And now, there was a lot of talk about these 5 events that were stipulated to in the document that Mr. Fisher used during his cross-examination, that stipulation agreement, you recall that?
Yes.
And now, you had a paper copy of that document, correct?
I have a electronic copy also, yes.
Okay. Well, then, can you actually open up the electronic copy for me?
That would be the stipulation and agreement?
Yes, ma'am.
Yes, I have it open.
And are you looking at it in a Adobe reader?
Yes.
What is the title of that document at the very top of the Adobe bar?
The title of the document?
Yes.
Of the Adobe file?
Yeah, on like the tab, the Adobe tab.
Okay. I've got several others open, so I can't see it all. Stipulation and agreement 2-15-2019.pdf.
Okay, is this the same copy that was emailed to the parties by Mr. Fisher on, I believe it was Monday?
Yeah, can I just ask that we clarify which stipulation we're talking about? I seem to have lost track.
Yeah, we're talking about the stipulation that was used by Mr. Fisher. It was the stipulation EO-2019-0132 and EO-2019-0133.
I may have renamed that when I saved it to the subdirectory where I was trying to organize what documents I may be asked to look at.
All right.
I can go back to the paper copy if you would like me to.
Oh, no, this has to do with the electronic copy, Ms. Mantle. I guess to maybe make this easier, Judge, I could share my screen with the actual email and original title of it.
Mr. Pringle, what relevance does the saved name of a document have to this proceeding?
It says MIA 3 minimum events.
Judge, I'll object to that. That was a designation I may have had on my computer whenever I sent it out. It has nothing to do with what what the actual document says.
Yeah, I'm failing to see the relevance, Mr. Pringle. Can you explain it?
To me, that event was that document was shared with all the parties being called a minimum events called. It kind of goes to say that number 5 that Mr. Fisher spent a lot of time discussing was intended to be a minimum number, not an exact number.
Judge, that it really is irrelevant what I had it designated in any computer.
Yeah, I'm not gonna allow you to ask her questions about that. If she knows what the document was meant, but I don't see how the naming convention has any relevance. Ms. Mantle didn't name it.
All right, thank you, Judge. I'll move on.
Thank you.
Now, Ms. Mantle, let me just pull up my questions real fast here. Now, if an adjustment is made in this case, the FAC prudence review, as opposed to an adjustment in the MIA prudence review docket, is it possible that this demand response issue may be raised in the company's next general rate case to reflect the imprudent action through the FAC?
It could be raised in the next rate case, but it would be retroactive. I don't know that I've ever seen the commission go back and get something like that.
But it is a possibility.
Yes.
And also, given the incentive structure in place for the Evergy DR programs, would a reasonable person have attempted to reduce the monthly peak in an attempt to minimize the Schedule 11 costs?
Yes.
And also, would a reasonable person target demand response events around times in which the highest market prices are incurred?
They would target it, especially initially in June, July, on when they expect market prices to be highest, make sure there's some events for reduction of peaks in the other, because you've got dueling objectives here. And you've got the objective of reducing the peak, but you also should have an objective, as they put in their tariff sheets, of reducing energy cost. So just as they work really hard to make sure they get the right peak, or the right hours to get the peak, they should work hard to get the hours of the highest price. Did that answer your question?
Yeah, that gave me what I needed, Ms. Mantle. And also, when it comes to calling demand response events, are you familiar enough with the MIA statute to understand the responsibility to maximize benefits?
I can't say that I am.
Well, thank you, Ms. Mantle. I have no further questions, Judge.
Thank you. Is there any further cross-examination based on commission questions from Evergy?
Yes, Judge, thank you. Good afternoon, Ms. Mantle. I just had a couple more follow-ups. Whenever you began your discussion with Judge DePel about the definition of purchase power, I think you were explaining that today the company bids in its generation and then it purchases back from SPP all of its needs. Is that right? Or that's at a very high level?
At a very high level. I still have trouble believing that megawatts offload to someplace at SPP and then SPP sends them back out. But that's the accounting method for doing it.
And is that correct that that's usually referred to as the integrated marketplace, the IM?
I don't know. It is done in the IM through the integrated market. Whether that's what it's fully known as, I don't know.
Okay. And about that time in your discussion with Judge DePel, you mentioned that peak periods are important. Would you elaborate why they're important from your perspective?
Well, first of all, utilities in Missouri are supposed to provide safe and adequate service and provide reliable service for their customers every hour, and whether it's peak or off-peak. So it's important to have energy available at the peak demand hour. SPP requires its load entities, the entities that also serve a load, to have enough capacity to meet its peak load plus its forecasted peak load plus a reserve margin, just in case some of the generation is not available. So it is a measure of whether or not a utility has enough generation to meet its load. And in this case, demand side is not the generation portion of that equation, it's more the load. So if you reduce the load, you don't have to have as much generation.
Well, just talking about the peak, would you agree that the programmable thermostat program is intended to help reduce system peak and thus defer the need for additional capacity?
Not in the case of Evergy, because you guys have so much excess capacity, you're not going to defer anything.
Well, if that's what the tariff said, would you dispute that was the stated purpose for the program?
That is the stated purpose. If it's in the tariff sheet, I don't have the tariff sheet in front of me.
Oh, I'll represent to you. I just read that. The voluntary programmable thermostat is intended to help reduce system peak load and thus defer the need for additional capacity. The program accomplishes this by cycling the participants' air conditioning units or heat pumps temporarily in a KCPL coordinated effort to limit overall system peak load. That's under the definition of purpose of the program. So would you agree that that's generally considered a purpose?
That's generally considered the purpose of demand response type of programs.
I was also interested in your discussion about how you chose I think it was a good start, the highest hours for 20 hours. You were discussing there the way you calculated your disallowance. Is that right?
I was discussing that. I don't know if your representation was exactly correct, but
Well, it
yes.
probably wasn't. I'd have to stipulate to that. But would you explain to me just one more time how you chose the top 20 hours that you used?
I did not choose those. They were provided in response to staff DR 42 in the MIA cases, where Evergy was asked for the market prices of the five highest market priced hours for the 2 summers. And that's the information I had. And so that I used that, multiplied each of those hourly prices by the megawatts available through the demand response program to come up with the amount of that customers were charged for energy that they didn't have to be charged for.
Okay, so you used the data from staff, which was actual data, correct? For those months, you knew what those hours were based on what actually happened during the month in the summer.
Assuming Evergy provided correct information to them, yes, I used that.
At the time,
it wasn't from staff, it was from Evergy.
Okay, well, at the time, as you mentioned, those really smart people at Evergy had to make the decision to call a curtailment event. Did they have that information available?
No, because I'm assuming these were the actual, so they would not have that at the time. They would have to make those decisions. They would have an estimate.
So you based your disallowance on hindsight information that was not available to the Evergy decision makers, correct?
for those 20 hours only. It's not like I went and picked the 80 top hours and applied the demand response in city megawatts to 80 hours, or even the residential and commercial to 60 hours. It was just those 20 hours. And for KCPL, it was only 16 hours in the summer of 2018.
And for KCPL, the decision makers at the time they made the decision to curtail would not have had that information available either, correct?
That is correct.
Is it your understanding that prudence is determined on a reasonableness standard based upon information that is available at the time, given all the circumstances that were known to the decision makers?
Can you repeat that?
Is it your understanding that under the reasonableness standard that's used by the commission in prudence cases, that it is based upon information that is available to the decision makers under all the circumstances that were known at the time they made their decisions?
I think that is the standard for determining whether or not something was imprudent. We've been discussing the amount, which I think is a different, you have to do with the information you have.
And would they have known at the time they had to make their curtailment decision that they had agreed to comply with an order that said they should do 5 during the summer?
I cannot say what they knew.
You would expect someone, though, that had entered into a stipulation in the past to know that information as they were trying to make a decision whether to curtail or not, correct?
No, the only person that I can assume knew that at that time, and even he may have forgotten it at Evergy, would be Roger Steiner, because his name was on the stipend agreement. I do not know if he was in the room when these decisions were made.
Those decisions the signature by Roger Steiner was on behalf of the corporation, is that right?
Yes.
Okay. Now, as I understand it, your testimony was, in your discussion with Judge DePel, was that you're recommending 14 events during the summer period, correct?
That's what my testimony, that is an answer to a question in my testimony. That is not the numbers that I generated.
Okay.
That would have only been like 9 or 10 events. It wasn't even the full 14 events.
Would that be a reasonable number to do in the coming summer for Evergy?
Yes.
What date should Evergy call 14 events in the summer of 2021?
They should call a total of 15. I had said they should call a total of 15 for 4 hours for the residential and commercial, and they should call a total of 10 for 8 hours apiece for the demand response incentive. In my testimony, I had 14 and 9, saving the 1 for operational considerations. By the end of September, they should know whether they are going to need that 1 for operational considerations. So therefore, to maximize the amount of energy savings, they should do 15 and 10.
On what date should Evergy call 15 and 10 events during the summer of 2021?
On days that they believe are going to be the monthly peaks, and on days that they believe market prices are going to be high.
And what days are those going to be?
If I knew that, I would not be working for OPC. I'd be on the stock market.
So a reasonable person has to understand the market at the time, not knowing what were the highest hours in the summer. Is that right?
A reasonable person would know that if the market price was above the cost of these demand response programs, which the majority is zero cost, they would know if the price of energy was going to be above zero, it could save money for its customers. And therefore, to maximize savings, whether it was the highest cost day, highest cost hour, or any hour above the price of zero, a reasonable person would know that they could save money for the customers and would take that action.
But at this point in time, sitting on the stand, you can't tell us what days we ought to do it, correct?
And no one can.
Okay, that's a good point. Thank you. That's all I have, Judge.
Thank you. Is there redirect from public counsel?
Yes, Your Honor. Good afternoon.
It's still morning unless you're on the East Coast time.
You're right.
By the way, thank you for your patience, Ms. Mantle. I wanted to thank you. I appreciate your answers. Thank you.
Let's start with the recross from Evergy. First of all, Evergy was asking a lot of questions regarding hindsight as to the calculated amount. Now, without actually determining whether or not you employed hindsight in calculating the amount, was there any hindsight involved in determining whether or not they acted imprudently?
No, there's no question to that.
And why is that?
Because, as I said to Mr. Fisher, anytime the cost of energy is above the cost of the demand response program, calling that demand response program will save the customers money. That will save energy that the customers do not have to pay for.
So because they save money any day that the cost of energy is positive, do you actually need to know exactly which days are the highest in order to be prudent?
No. To maximize prudency, you have to know that. But prudent people don't know that, and prudent people would do the best that they could.
Are you suggesting that they call all 15 events on the first day of the curtailment period?
That would be imprudent.
What would a prudent person do?
A prudent person would know what the load characteristics of the Evergy utilities were, and they would know the response to the weather. They would use a few events, 2 or 3, to get the peak in June, and then trying to get the peak in July, and knowing that there's the hot weathers, typically in July and August. That's when you would try to use, maximize your events. And then in addition, you'd save a few events for September, trying to get that peak. But even if you didn't get the actual peak in September, you only had 2 events left and you missed the peak, you would still call those events because you are saving the customers money.
Would a reasonable person review information like the day-ahead market, weather reports, et cetera, the same way you're trying to predict a peak when trying to predict when to call the events for economic reasons?
Definitely. They'd have a good feel not only for the load of the utility, but also the SPP market and what drives those market prices.
So when you were asked, how do you predict what peaks, or when you were asked what a reasonable person would know, and you said no one could know, what did you mean by that exactly?
No one can pick a specific date. You can know it's going to be Monday through Friday. You can know that it's likely to be about 4 p.m. in the summer months, but as to whether it's August 6th or August 12th or July 27th, there's no way you can know because you don't know the weather on those days.
But you can make reasonable predictions based on the information that's available and act prudently by choosing to call events at all.
That's correct, you can.
You were asked some questions by counsel for Evergy regarding the purpose of the demand response programs. Even if the tariff had purpose language, does that preclude Evergy from using the tools available in those programs to act prudently in other situations?
No, it does not. We expect Evergy to use its generation efficiently and effectively, and we should expect the same of them with their demand side programs, all of them.
Did the demand side programs allow for a purpose outside of the stated purpose of reducing capacity, or maybe not reducing capacity, but I think you know what I mean?
The tariffs themselves show that Evergy, one of the purposes that it could be used for was economic reasons, which is exactly what we are claiming they did not do. And so therefore there is another purpose, and every tool should be used effectively. And this is a tool that was not used effectively to reduce costs for Evergy, or Evergy's customers. It made very little difference to Evergy itself.
I'm going to move on to some of the questions you were asked directly by the commission. First off, there's been, in describing how you calculated your disallowance, there's been a lot of talk of the number of hours and the number of events. And I want to make sure that there's some clarity here. So is each event 1 hour?
No, for the residential and commercial thermostat programs, they are, they can call up to 15 in the months of June through September, and each of those can be up to 4 hours long.
So 15 events up to 4 hours long.
For a total of 60 hours. And for the industrial program, they allow 10 events, and then they also, but those events can last as long as 8 hours for a total of 80 hours. And probably also notable is that Evergy has a tariff allowing those same customers to take advantage of the marketplace and reduce their loads during high market prices, and that money goes straight back to those customers.
So for the 20 hours that you looked at, do you have an idea of how many events that would actually correlate to?
When I was careful of that when I went and priced this out, and I calculated for summer of 2018, it would have been, I think, 9 events, and most of those events were an hour or 2 hours long. They were not the full 4 hours that the company could call for. And in 2019, it did get up to 10 events, but again, those were not, each of those were not 4 hours long.
There was some significant discussion regarding the 5 events that kind of were called in 2019 for the residential thermostat program, so the 5 events alluded to by Mr. File. How many hours then combined were in those 5 events? Do you know?
From my work papers or?
For the 5 events that were actually called in 2019.
Well, I believe it was Mr. Fisher's presentation that said it was from 4 to 6, which means it would be from 4 to 5 and 5 to 6. So 2 hours long, 5 events, 2 hours apiece, that's 10 hours.
Obviously, you spoke at length about how you considered your number to be conservative. Just to be clear, is the OPC asking for a greater disallowance than what you recommended?
No.
I think we've kind of touched on this, but some of the earliest questions you received from the commission were describing peaks. What factors do you need to consider when trying to select peaks? Is reducing peaks the only consideration that Evergy needs to be making when it's considering whether to call a demand response program?
No, it should be, market price should also be reviewed, especially if you know you've already gotten the peak for that month and reduced peaks. But even if you haven't and you're running out a month, and running out of the curtailment season, getting to the end of September, and you've got available events, and again, anytime the market price is above 0, you will save the customers money if you call these events.
All right, let's go to the original cross-examination of Evergy. And one of the last things you were kind of asked about was this concept of arbitrage. Do you recall that?
Yes.
All right. And you were asked, you know, isn't it possible the day-ahead markets might be wrong? Do you recall being asked similar questions similar to that at least?
The day-ahead market will always be wrong. The real-time market is the one but you have to plan off the day ahead.
Let's make sure we're clear here. When you say wrong, you just mean that it's not the actual number.
It's not the day-ahead price. Sometimes
Right.
it's more, sometimes it's less.
How often are you going to expect a wild or significant difference between the day-ahead and the actual market price?
While I do not have a number, I do know that if that happens a lot, the market isn't working like it should. The participants cannot plan very well, and they cannot offer into the market. That's an unstable market, and SPP will work to reduce that amount so that it has a stable market.
So is it reasonable then to say that it's highly likely the day-ahead market will be close to the actual market price, or one should expect it at least?
I believe participants expect it to be close. That's how they make their bids. That's how they know what costs they're going to incur.
You know, part of that discussion was focused on the idea that, you know, if Evergy gets these wrong, these costs are going to flow to the FAC. Does Evergy engage in any other kind of speculative ventures that also flow to the FAC?
All the time, and the biggest that come to my mind right now are the wind PPAs that Evergy has entered into to make money for the customers, of which they've lost hundreds of millions of dollars the customers have had to pay for. So in that case, Evergy is perfectly fine with gambling with hundreds of millions of the customers' dollars because that flows directly through the FAC. And here, they're unwilling to do take these risks for a very small amount of money.
One of the conversations that you had with Evergy on Cross was talking about when to push the button, so to speak. Do you kind of recall what I'm referring to?
Yes.
Actually, this is something we might have already touched on a little bit earlier, but in your surrebuttal, you explain what a prudent person would do looking at the market and how they would select peaks. Is that correct?
That's correct.
At the risk of maybe repeating ourselves, can you basically describe what exactly a prudent person, what would you expect a prudent person to do, in your professional opinion?
And in this instance, I would expect, and I'm not a risk taker, but I would expect a prudent person to maximize the benefits from this program. And that would mean trying to hit the peaks, trying to hit the hours where the market price was the highest, and at the very least, using that resource and the number of resource or events allowable to maximize the benefits to the customers.
So even if they don't hit the peaks, even if they don't hit the highest prices, it's still imprudent if they don't try and even attempt to call them, the demand response events?
If they do not attempt to call them, the customers lose. It's just that simple. By not doing anything, the customers lose.
It's that whole, you miss 100% of the shots you don't take scenario, right?
That doing nothing is a choice.
So obviously, you know, in the Evergy Cross, we had a lot of conversation regarding this stipulation, and I want to talk to you a little bit about it. Now, first of all, this stipulation only covered 2019, correct?
That is correct.
So even if we assume that it controls for 2019, this prudence review period also covers 2018, right?
It covers the summer of 2018. It starts in June of 2018 for Evergy West, and it starts in July of 2018 for Evergy Metro.
So even if the commission were to find that this stipulation controlled, Evergy would still have been imprudent for the summer of 2018.
That is correct.
Absolutely.
And I believe that was the impetus of this stipend agreement. They weren't calling.
Do you have the STIP in front of you?
Yes, I do.
Can you go to page 3 for me?
Okay.
So I'm not going to ask you to read the whole thing. That's a bit tedious. But if you'll just read to yourself number 7, and then you don't need to read A and B, just.
Okay.
Based on that language, is your interpretation that A and B were exceptions to a requirement that they increase their demand saving targets?
That is not how I would read it.
How would you read it?
I read it that they're going to increase the savings targets. And as a part of that, at least A and B would be done. A and B were not, I don't believe were the only things that could be done to increase the target, but at least A and B would be done.
As far as subsection B goes, it says you would agree that it says the company will call 5 demand response events per jurisdiction during the summer of 2019.
That is what it says.
If a company called 6 events, do they also call 5 events necessarily?
Yes.
So if a company had called 6 or more events, would, in your opinion, they be in compliance with this provision?
Definitely.
Is there anything in this provision that says you shall not call more than 5 events?
I have not seen it.
Is there anything in this document that refers to the FAC? Admittedly, it'll probably take a moment to actually go through the document. Please take your time.
I did a search and find on the letters FAC, and it was used in the document only as parts of words like factors and facsimile. It was, the fuel adjustment clause was not mentioned in this document.
Is there anything about this document that would suggest to you that Evergy was absolving itself of its responsibility to act prudently outside of the MIA?
Can you repeat that question again?
Was there anything in this document that suggested to you, or suggests to you, present tense, that Evergy was absolving itself of its responsibility to act prudently outside of a MIA context?
Oh, no. That should be expected all the time.
And even if Evergy had settled a MIA case, would you still expect them to be prudent in an FAC case, or with regard to its fuel purchasing provisions?
Yes, because it's not done, and one is not done as a silo to the other. Each affects the other.
This might be a tricky question because you might not remember, but you were asked a question regarding something Mr. File had said previously, and you had more to say in response, but you were cut off. I don't know if you recall what you were going to say.
Yes, Mr. File in his response, or in his testimony yesterday, stated that, well, he thought that if they had it was his opinion, if they had to have more than, or if they wanted to do more than 5, they would have to go to the other parties and get permission to not follow this step. A prudent person, knowing that he can achieve more benefits for the customers, would have come and asked, can we, if they thought they were constrained to this stipend agreement, a prudent person would say, I can save more money if I increase that number, and would have come and asked to increase that number. And I am not aware that I'm pretty sure that would have been brought up if Evergy had done that, had tried to have more than 5 events, but the other parties told them no.
Do you still have it open in front of you, the stipulation, I mean?
Yes.
If you went to page 7 and saw paragraph number 21,
That is, it just may be modified by the signatories only by a written amendment executed by all the signatories.
so is that reinforcing your position that they could have asked for more events?
Definitely. And I have a hard time believing staff or OPC would have said no.
To your knowledge, did they approach us?
Not to my knowledge.
And you were asked some questions regarding the $25 that residential thermostat customers receive as part of the residential thermostat program. Do you kind of recall that question?
Yes.
Now, according to the testimony of Mr. File, Evergy designed this program to allow for 15 residential events to be called. Is that correct?
That's my understanding of his testimony.
Given that they designed the program for 15 events, is it your opinion that they must have assumed the $25 was sufficient incentive to get 15
Objection.
events?
Objection, Your Honor. Calls for speculation on what Evergy might have thought.
I'll sustain that, Mr. Kleiser. Okay.
Let's move on to the cross that staff offered. Staff asked you a question regarding the fact that the demand response program is funded to the DSIM. Do you recall that?
I recall that.
Could the failure to properly utilize a program create costs that should flow through the FAC even if the underlying program was pursuant to a separate statute or a separate recovery mechanism?
Definitely. Just as the building or the inefficient utilization of a power plant, those costs flow through regular rates. Inefficient use of that causes increased cost in the FAC. So again, they're both resources, similar in that the initial capital costs are recovered through different mechanisms, but they affect the FAC.
I believe that concludes my redirect. Thank you, Your Honor.
Thank you, Mr. Kleiser. All right, then I believe that concludes Ms. Mantle's testimony. I do want to just clarify again about the data request and that number. In reviewing Mr. Lubert's testimony, it looks like he mentions data request 41, but then discusses a response, a data request response number 42. I just want to make sure we're all on the same page, that we think now that that is data request number 42 is the one with that, or the response to data request number 42 is the accurate item. Is that everyone's understanding?
We are verifying.
Okay,
I was gonna say, nobody responded, correct?
correct.
Yeah, if it's the day ahead LMP, it is DR 42 from the MIA proof review case, EO-2020-0227.
Okay,
And the 228 also.
And 228.
And that's also the case that's EO-2020-0228. Is it 0228? Yes, because it was one for one utility and another for the other. But both of them is number 42.
okay, thank you, Ms. Mantle. Mr. Steiner, I'm sorry, I muted you because you apparently have something going on in your office. If you need to evacuate, please do. Mr. Fisher, do you have any
Judge.
idea what Mr. Steiner was trying to tell us?
I think he was trying to tell us that it's at 42.
Okay. Okay, we appreciate one of the issues of technology. We appreciate not hearing the building alarms going off in Kansas City.
Judge, we do appreciate all the technology that you've had to deal with to get us through this. So thank you.
We're all learning together here. So, all right. Well, I think that will take care of that for now. And once the building alarms stop, if Mr. Steiner has something to add, he can do so. Okay, I know I made the witnesses stick around, and I appreciate that. I don't believe I'm going to need to call any of them back, but I do want to, before I say that conclusively, we talked about, I had asked Mr. File to find those numbers, and you believed that he had those numbers now, Mr. Fisher, was that correct?
I'm not sure I know which numbers you're talking
Oh,
about.
I'm sorry, the percentages. And
Hi, Judge. With fire alarms over, we're all safe. So sorry about that.
that's all right.
So I didn't really hear what was said, so I apologize for that. So we think it's DR 42, and we would submit that tomorrow in our filing.
Okay, I think we've all agreed that that is the correct one. So I asked Mr. File a couple of questions yesterday and about the percentages. And now I'm trying to remember the
Load ratio share?
yes, that one.
I'm going to file, I have that information. I was going to file that tomorrow as well.
Okay, very good. As long as that can be considered a fact in the case so that we can use it, as long as it becomes part of the testimony.
Well, the file I was going to make, I guess, was going to be late filed exhibits. I mean, they're the tariffs, the load ratio share, and this DR 42. How would you
That
like
will
me to
work.
designate it?
Just designate it as a late filed exhibit, and then I will number it and mark it, and we will get responses that way.
Okay.
And then once there's no objections, I'll admit it at that point. Okay, that will work. So we have that, and we have the other tariffs that OPC is going to do the same way. They're going to file those I'm going to mark them. I'm going to give them a number for identification purposes, even though it's something we were going to take official notice of.
Given that, Judge, would you prefer that I style it as a motion to take administrative notice or notice for late filed exhibit?
Just you could go ahead and call it a notice for the tariffs, because that's how we're going to treat it. And let's see. So with that, I believe that the witnesses are all dismissed. We're finally done with you, and
Sorry,
I
Judge,
appreciate your patience.
we had more notice over the PA system. What was the last exchange? How is OPC going to entitle their tariff filing?
They're going to title for the tariffs. Those are going to be a request to take official notice, and for the for your DR, you can say that that's a late filed exhibit.
So call the tariffs late official notice, and call a press for additional official notice. What should I call the load ratio share amounts?
You can just call that a late filed exhibit.
Okay.
Okay, and then like I say, I will give them exhibit numbers just for identification purposes in your citations, in your briefs, and so forth. And I will put out a notice asking for an order directing you to file any objections to those items. And I had originally ordered that the transcripts would be available on February 11th. And I believe that that's still how they will be. And we had set February 22nd as initial briefs and reply briefs on March 8th. Is everyone still okay with those dates? Not seeing any objection, so we will assume that that is fine. I would like to remind you to please type to the record so that I can easily follow your arguments. I would also like you to cite to any law and statutes, cases, commission precedent, or tariffs that are necessary to understand this. Specifically, I would like you to set out the standard, the burden of proof, when that shifts, who has the burden of proof, and so forth. And I think that is everything that I had on my list that specifically needed to be taken care of. Were there any other questions or items that needed to be addressed while we're on the record?
Late filed exhibits and notices for administrative notice are to be filed by tomorrow, and objections to the same are to be filed by
a week from today. Yes.
A week from today. Thank you.
Any other questions? Okay, well, once again, I do appreciate your patience with the technology and with my cat's appearance and Mr. Pringle's cat's appearance. I appreciate that his cat decided to get in on the action too, so I wasn't the only one.
Judge, speaking of your cat, I noticed at one point this morning, the cat was in the background and then you went off camera and came back and the cat was gone. I just want to make sure the cat is still fine.
The cat is now in kitty prison, but he is fine.
Oh, okay. Okay.
Okay, I believe then that we have accomplished everything we need to while we're on the record. I appreciate your patience and your attendance. And if there's nothing further, then we can go off the record.
Thank you, Judge.
Have
you,
a
Judge.
good day. And Ms. Banks, I'm going to be emailing you that document.
Okay, I just want to confirm which commissioners were on. I have Coleman, Holzman, and Sylvie. Is there anybody else I missed?
Hold on just one moment.
Okay.
I want to stop our internet broadcast
Oh, okay.
before we have additional discussions.